3,000 of you asked me to respond to this video where Carlton Dennis claims you can deduct a private chef as long as you have daily business meals at your home. And if you don't know me, I'm Jasmine DeLucci. I'm a tax attorney, CPA, and an enrolled agent. And I recently got onto social media, even though my day-to-day is actually running my CPA firm and my tax law firm, but I do it to show you actual tax law. So Carlton's big idea is that you can deduct your daily meals. He's so confident in it that he's saying he does it himself. It sounds wrong, which is why all of you guys asked me to respond, but after this video, you'll know exactly why it is dead wrong. So let's break down the actual tax law, including court cases, showing the decades of established precedent so that we know why Carlton's own personal chef deduction is not on solid legal ground. So before we get into some very detailed tax law, let's go through the foundation of how tax law even works. Tax law has hierarchy, okay? At the top, we have statute. That's the Internal Revenue Code, and while it is at the top, it usually contains a very small percentage of the details. That's why almost every illegal tax shelter and tax guru social post is born out of statute, because it ignores the majority of the tax law and detailed interpretation by Treasury and tax court judges whose opinions on the statutes are the only ones that matter. And what happens over time is we have enough court cases that we have very established law in the area, and that's what we have here for daily meals, okay? We have decades of cases on this topic, so we have a very clear rule when it comes to daily meals. To ignore it is not legal. For business meals, the relevant statute is IRC 162A, ordinary necessary business expenses, as I'm sure you've heard that cited a lot of times. But now let's go through the meat of the tax law for daily meals, which is the court cases. And I picked out several court cases that demonstrate the rule for daily meals across decades, and of course include the most important case that almost all future cases now cite back to as the main case. These cases are going to show you when daily meals actually are deductible, which is almost never, and how they are absolutely not deductible in Carlton's private chef scenario. First, we have Sutter v. Commissioner, okay? This is what gave us the Sutter rule in 1953, and it's an old court case because it is not a new idea to think about deducting meals on a business. And in this case, we learn the premise behind allowing a deduction for business meals, which is that you can only deduct meal expenses if you prove they are different or more than what you'd spend on personal meals. Okay, the court states that there is presumptive non-deductibility of meals that may only be overcome by clear and convincing evidence that the expenditure in question was different from or in excess of what would have otherwise been made for the taxpayer's personal purposes. And this is because personal expenses are non-deductible under another code section, which is IRC 262. Let's think of a classic example here, okay? You would normally be fine with your wife's homemade PB&J sandwich on a regular Thursday lunch, but you want to take out a potential client to lunch to gain the business. Do you A, take that potential client to lunch and bring your wife's homemade PB&J sandwich to eat for yourself? Or B, eat at that fancy restaurant and order more expensive food than you otherwise normally would, because eating the PB&J at the restaurant in front of your potential client would be super weird. Almost everyone would say B. And that's the idea. There's a precedent set all the way back to the 1950s from Sutter v. Commissioner that meals should be presumed personal unless you can show that they'd be different than what you otherwise would have done personally at that time. Second case, we have Howard v. Commissioner. In 1981, this allowed a meals deduction for the taxpayers who hosted private dinners with prominent guests once a month at their home, and with the most significant deciding factor being the fact that they were infrequent dinners, okay? Like everywhere in this section, the court keeps repeating infrequent, 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 because that was core to their decision to allow meals. They also cared about the fact that there were other social events that looked similar, but were specifically not deductible because they were not commercially motivated. A theme that you are starting to see here is that whether or not there was a business discussion or business purpose isn't the challenge, right? It's the full facts and circumstances surrounding the meals. If you're having meals frequently, that indicate this is something usual to you, then it is indicating it is something personal to you, in which case the courts say it is not deductible. All right, third, we have our outliers. So we have two court cases when daily meals do become deductible. In Cibla v. Commissioner, a Ninth Circuit 1980 case, and Cooper v. Commissioner, a 1977 case, both cases involved Los Angeles firemen who were required by law to contribute to a meal fund for each day that they were on duty, regardless of whether they ate or were even present at the fire station. One of the firemen was literally threatened with dismissal when he refused to pay for days when he was on duty but not at the station, and in describing why the daily meals deduction was allowed, the court said the involuntary nature of the payment and the taxpayer's limited ability to eat the meal for which he was paying combined to create a unique circumstance which justified allowance of the deduction. And what's important to note here is that even though it was required by law for them to contribute, they still had to go all the way up to tax court and circuit court to win the cases. Finally, in 1985, we have our big case, okay? Once this happens, basically every daily meal case cites back to it. It is Moss v. Commissioner, when the taxpayer lost his daily meals argument in court and then, of course, appealed to the Seventh Circuit, where he lost again. The taxpayers were partners at a law firm, and they met with other partners and associates at a local cafe for lunch. That is right. Every day, okay? They would discuss their cases and settlements, and there was no dispute that the meals were business driven. And from the tax court before appeal, we get our most cited sentence by all future court cases, okay? The quote from the case is, "Daily meals are an inherently personal expense, and a taxpayer bears a heavy burden in proving they are routinely deductible." The appeals court then drives this point home by saying, this is my favorite, "We may assume it was necessary for Moss's firm to meet daily to coordinate the work of the firm, and also, as the tax court found, that lunch was the most convenient time, but it does not then follow that the expense of the lunch was a necessary business expense." Appeals then states, okay, there's some other good stuff here, "The problem is that many expenses are simultaneously business expenses in the sense that they conduce to the production of business income, and personal expenses in the sense that they raise personal awareness. This is plain enough. With regard to lunch, most people would eat lunch even if they didn't work." And then it says, read literally, the statute, section 262, would make irrelevant whether a business expense is also a personal expense, so as long as it is ordinary and necessary in the taxpayer's business, thus bringing 162A into play. An expense is, the statute seems to say, deductible from his income tax. But the statute has not been read literally. Let's stop there for a minute. This is why people who do not know how to do tax research think they're a genius. They read the law literally and they're like, well, shit, all of these actual licensed and practicing tax professionals are wrong. And then they go prancing all over the internet talking about how they're a tax strategist and have some proprietary strategy skills when it is literally born out of straight ignorance. So back on the Moss case, okay, the appeals court, of course, then denied the daily meal deductions, saying that they were inherently personal. Also citing the Sutter rule, saying that the same cafe every day was not more or different than they otherwise would do personally. And since this case, pretty much every daily meal court case cites Moss before denying the daily meals deducted. A couple of examples. Both Dugan v. Commissioner, a 1998 case, and Fitch v. Commissioner, a 2012 case, both courts cite Moss v. Commissioner, saying that the daily meals were personal, even though it wasn't in dispute that business was discussed at all of the meals. And in fact, in Fitch v. Commissioner, one of the taxpayers was a CPA. So there you have it, the actual tax law. And if you like this video and you have as much fun as I do learning about tax court cases and you want more like it, then comment and let me know. That is actually how I know what type of content you want me to make. And as always, for more accurate tax law from a tax attorney, CPA, and enrolled agent, subscribe.